new marshal, pay good attention.
Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Be more dramatic than that. It's our new marshal, Aaron Souls. He just joined us last week, and one of his first times introducing us. So we'll send out a survey and see how you guys can grade him, see how you did. So.
Were we supposed to applaud?
Yeah, he did it without, he actually got all the words right. That was a good job. It's on his way. Two for two, I guess. All right. Good morning. Welcome to another session of oral argument before the 5th District Court of Appeal. As our marshal just eloquently stated, I'm Brian Lambert. I'm the Chief Judge presently for another 227 days or so. So I'll be presiding over the arguments this morning. We have two cases on the docket. Our first case that was previously scheduled we dispensed with, so we're down to two cases. Let me introduce the panel. To my right and to your left is Judge Carrie Vander, and to my left, your right, is Judge Rand Wallace. I know we don't have a big audience other than Ray, who's a big fan of oral arguments out there. But if you have any electronic devices or cell phones, please turn them either off or in the mute position so that you don't interfere with the other opposing counsel when arguments are going on or with the court. Each side will have 20 minutes for argument. We are being videotaped or on YouTube, so keep that in mind. The appellant, I'll set aside 5 minutes for rebuttal unless you tell me you want a different amount of time, and let me know, and I'll adjust the clock accordingly. You'll see on the podium there as the clock winds down and you get into either your rebuttal time or your expired time, either the yellow light or the red light will start flashing to let you know where you are. I will notify the appellant if you're getting into your rebuttal time. If you want to keep going, obviously you can use as much time as you want, but you don't get bonus time. So. All right, that being said, our first case today, I'll give it my best shot here. Sophia Digzlewski versus Bonnie Scalero et al. I apologize we'll refer to her as the buyer. How about that? Well, I apologize for mispronouncing her name. If you tell us the correct pronunciation, we'll get it correctly on our record here. So, whenever you're ready, counsel, you can proceed.
Thank you, Your Honor. If it please the court, my name is Alan Whitehead, and I'm representing the plaintiff, buyer, Sophia Jegilewski.
Jegilewski, okay, thank you.
And, Judge, I'll just briefly go over the facts.
Let me ask, do you want 5 minutes is good for rebuttal?
Yes, sir.
Okay, that's fine.
Yes, sir, that's fine. Thank you. Generally speaking, the facts are easy in a case like this because we assume that the facts in the amended complaint and that have been pled are true for purposes of the motion to dismiss that was granted with prejudice. And according to the amended complaint, in October of 2019, this real estate agent who is Miss Scalera, the defendant that was dismissed with prejudice after an amended complaint was filed, the second complaint directed toward Ms. Scalero, that in October of 2019, she was advised that by the condominium association that this particular unit did not convey with the exclusive right to use 3 garage spaces.
Mr. Whitehead?
Yes, sir.
I have one question right now, and my question is, prior to the closing, what documentation did your client receive that would indicate to her in writing, any line items in writing that would indicate that she is not receiving title to or rights to more than just 1 garage space?
I don't believe she received, certainly there's nothing in the amended complaint and in the record to show that she received any documents saying that she wasn't getting those 3 garage spaces.
Wasn't there at some point in the contract for purchase of real estate, there was an indication that although originally there was rights to 2 additional garage spaces, and I'm referring to, I think it's the standards for real estate transactions continued. I think at the bottom I have a handwritten number 9. There's additional terms, and I believe there was some indication in that printed form that there would be maybe potentially an inability to have control over 2 of the 3 garage spaces. Is that correct?
There is a provision at paragraph 20, the typewritten provision in the contract, that does state this: seller is the rightful owner of record of unit 301 together with garages 19A, 9A, and 11A, as evidenced by deeds recorded in Brevard County Clerk of Court. Due to deficient and missing documents dating back to when the condominium was developed in 1978, the seller can only guarantee title to Unit 301 and garage number 19A. That is included in the contract for sale and purchase. The problem with that, and I understand what you're saying, is does that, and this is what I think, quite frankly, is the strongest point that the appellees have on appeal, and the question that we need to overcome for purpose of prevailing on this appeal is, does that state that you're not getting the exclusive right to use 3 garage spaces? And understand that in a condominium, a garage space, and in this condominium in particular, garage space is a limited common element. You don't get ownership of the garage space. You get the exclusive right to use that garage space. This is dealing with ownership, number one. It's not dealing with the exclusive right to use. And those were the representations that were made, that you have the exclusive right to use these 3 garage spaces. And this is not dealing with that. The second point on that issue is, if you look at paragraph R of the general provisions in the standard contract, it's paragraph R found at
Page 10 of 12?
yes, sir, I believe. And that says, Riders addenda, typewritten or handwritten provisions. Riders addenda and typewritten or handwritten provisions shall control all printed provisions of this contract in conflict therewith. Then you turn to the addendum to the contract, and in the contract addendum, it expressly states, this is the condominium rider addendum, paragraph 8, common elements parking, and it expressly states that these shall be assigned to the buyer at closing, and it identifies garages number 19A, 9A, and 11A, saying that she's going to get the exclusive right to use those. And in fact, Ms. Jigalewski, unlike a lot of the clients that I have that don't read these contracts before they go into these transactions, she did read it. She saw paragraph 20. She asked the question of Ms. Scalero, wait a minute, you've represented to me that I'm getting the exclusive right to use these 3 garages, and she was told, you do have the exclusive right to use these 3 garages, as indicated in the addendum. That's what controls the right to use these garages, not that provision at paragraph 20.
Let me ask you this. Paragraph R of the main contract says, Riders, addenda, and typewritten or handwritten provisions shall control all printed provisions of the contract in conflict with them. If we were to assume that these 2 provisions are in conflict, paragraph 20, which is typewritten, and the rider, is there any argument that one has greater weight than, should be given greater weight than the other, or they kind of come in as a tie situation?
I believe that based upon the representation that was made by Ms. Scalera, the addendum would control over the body of the contract. Now, I don't think, but we have this rule of construction that we have to try to read these provisions consistently if we can, and I think we can. I think one talks about title and the other one talks about use. And so when you're dealing with a garage space, you don't get title to the garage space in a condominium. You get the exclusive right to use the garage that's attached as a limited common element. And in this case, it's clear that the representations that were made by Ms. Scalero was that you have attached to this unit 3 garage spaces. And I think that looking at all of that, for purposes of a motion to dismiss and assuming that everything's true, that it was clearly a mistake to grant a dismissal with prejudice based upon, if that was the reason, it's not 100% clear, but if that was the reason that this contract somehow contradicts the allegations in the 4 corners of the complaint and nullifies the claim, then I don't think it's clear from looking at it without going further and delving into facts and evidence, and especially assuming that what we allege in the complaint is true, which is, hey, I see this provision in the contract. You told me I'm getting the exclusive right to use 3 garages, and then being told, yes, you are. Look at the addendum. I mean, that is fraud.
What if there was no rider? What if that language that added had the 3 garage spaces and the rider wasn't there?
Even if the rider wasn't there, I don't think that paragraph 20 conflicts with the misrepresentation that was made. Paragraph 20 is dealing with title to the garages. It's kind of a misnomer, if you will. You don't get title to garages. I mean, they're claiming that you do, but you don't. And you get the exclusive right to use those limited common elements. I'm happy to go on. It sounds like everyone's up to speed on the facts, but there was another argument that was raised, which is whether or not this paragraph 14, which says that you are exclusively relying upon representations made by the seller and not by the realtor, and whether or not that would nullify the claim. I think that may be why, again, it's not clear from the judge's ruling, but that may be why he ruled on the motion to dismiss and granted it with prejudice. It appears to be in line, and we have 2 of the 3 judges on the panel today for the Smith decision, but it appears to be in line with that decision as to whether or not fraud and the inducement, Chapter 475, sort of allow for a fraud and the inducement claim based upon, notwithstanding the language of paragraph 14 in the contract.
In other words, you can bring a fraud and the inducement claim.
You can bring a
regardless of
fraud and the
paragraph
inducement
14.
claim, you can bring a Chapter 475 claim, which we did not bring, but at the conclusion of the hearing, I asked for an opportunity to amend, which Judge Jacobus denied.
In your motion for rehearing, you also mentioned Smith versus Rodriguez.
I'm sorry, Judge Evander, I don't remember whether we did or not. We may not have. I just don't remember. It was one of those situations that I went into the hearing with the understanding that fraud and the inducement will stand, notwithstanding a merger clause in a contract, notwithstanding any other provision in a contract, because the fraud occurs prior to the contract being signed. And that was the body of law that I was considering as we went forward with the motion to dismiss. And I wish I had had the Smith decision in my briefcase at that hearing to present it to the judge, and
Purposes
it
of your
did not.
request to amend, to add the cause of action?
I'm sorry, Your Honor?
For purpose of asking for leave to amend?
Yes, sir.
Because you hadn't pled a Chapter 475.
I had not yet platted Chapter 475 claim, but we did have, we believe, a properly pled fraud and the inducement claim. And the other claim was a negligent misrepresentation claim.
I mean, if I'm understanding, or correct me if I'm wrong, I mean, the judge didn't say that your claim was not sufficiently pled, nor does that seem to be what the appellee was raising. I mean, it seemed like the appellee was saying, look, this is, you lose, look what the documents say. I mean, and oh, by the way, you did get 3 garage spaces anyways in one of the deeds, I guess, is what.
He
I know
expressly, the Judge Jacobus expressly stated that he was not considering the deed which there was a request for judicial notice to look at the deed, because that was a position that was taken by the appellee, that we got a warranty deed that shows 3 garage spaces on the warranty deed.
And the judge was right that you can't take judicial notice for purposes of defeating a motion to dismiss.
He did not take judicial
Right,
notice. He
and
did
and that was a
not.
correct ruling by him.
I believe so, yes. And but I think I think he based it on paragraph 14, but he didn't expressly state that. He might have based it on what he believed was a conflict between the contract, as we've discussed earlier today, and the allegations in the complaint. But
He required to say what he was basing on in the context of our new motion for rehearing rule, that, you know, you have to move for rehearing if the judge didn't make sufficient factual findings, et cetera. Was he required to say, here's why I'm dismissing it because of A, B, C, and?
I know that that's the case for summary judgment. I wish I did for purposes of today. I just don't know if he had to do that for a motion to dismiss. But certainly, the new motion for summary judgment rule requires it. If there are no other questions, I'll reserve the remaining portion of my time for rebuttal.
Okay, thank you.
Thank you.
Good morning.
Morning. May it please the court, my name is Scott Wiederman. I am here on behalf of the appellees, Ms. Poser, Scalero et al. Let's take right out of the gate some of the issues that were brought up initially by the appellant. First of all, Your Honor, I think there is a very direct relation to paragraph 20 of the contract as well as the addendum. The addendum doesn't talk about exclusive use, first of all. It says use. It gets an assignment of an undivided interest in a common element. And then as it goes further down, seller's right and interest or to use the following spaces. While I don't disagree that title to garages being owned by the condo association and being a limited common element that are assigned, the sale document itself is very specific in disclosing that exclusive use, whether you call it assignment or whether you call it the title or whether you call it whatever you call it, is specifically acknowledged within paragraph 20 of the contract as being a question. There was no argument, or there is no counter argument, frankly, from us that says we don't have and are not giving a title to, because that's what we had. The bargain for exchange is what bundle of sticks we own and what we're then transferring to the next party. There, in fact, is no claim of ownership or assignment of the limited common element of these 2 garages by anyone else. It's just from our sale, and it follows the deed from the beginning of these units as far back as the title insurance company goes back and finds. And our client, the appellee, is not the required party to examine title. The title company did that, transferred exactly bundle of sticks that we have with the knowledge that the documentation to the beginning of time of the association doesn't cover us going back that far.
Well, did you have a duty to disclose that the condo association was making an adverse claim?
No, because the condo association is not the finder of fact or the trier of those issues.
That's not the question. The question was, did you have a duty to disclose that the condo association had an adverse claim on those parking spaces?
We have a duty to disclose all latent defects. If we're going to call what the condo association says as far as the non-ownership, which is what their claim was, ownership, then yes, which we did in paragraph 20.
Well, the writer says in paragraph, let's see, you have a provision that says that you all, let's see, seller represents that seller is not aware of pending or anticipated litigation, including the property or the common elements, if any, except as follows. And it's left blank. That's 3D of the writer.
Yes, sir, and there is, that provision is 100% completely followed. We know of no litigation pending, no possible litigation pending.
What do you mean, no possible litigation? Didn't you have an estoppel letter, alleged, at least if we accept the allegations of the complaint is true, didn't you have an estoppel letter indicating that someone, i.e. the condo association, did have an adverse claim?
For this particular purchase, no, Your Honor. For the prior purchase that didn't go through, yes, Your Honor. And the estoppel letter is still only the opinion of the condo association, not about litigation, not about anything else, as to what is in our bundle of sticks that we own. And Your Honor, the title company provides that, not the seller. So when the title company comes and says, here's my bundle of sticks that I'm transferring to you, and here's how I give that title, and here's how I follow that chain to do so, I believe they complied exactly with 3 in the rider.
Well, in your complaint, in your answer brief, you say that, as far as your standing argument, your tips of coachman argument, the plaintiff could file suit against the condo association and seek a determination of who actually owns the garages that the plaintiff received a warranty deed for prior to filing this suit.
Sure, and
Okay, well, if that's the case, that kind of suggests there was anticipated litigation with the condo association over the garage sales.
from a legal perspective, Your Honor, saying if the condo association somehow has the authority, which it does not by law, to determine what limited common element they're going to repair or not going to repair, and what element is or isn't transferred via deed, then her cause of action, if they're actually stopping her, which she says in her declaration, no one's stopping me from using it. I got all the keys, I got everything I need. Somebody just said so one day. Then that is a remedy allowable, but we don't think it's necessary. We've transferred what we had.
We don't know if the condo association has a valid claim or not based on what's in the complaint, do we? I mean, the condo docs may say something to the contrary. There might be some other deeds that say something to the contrary. But it seems to me that, at least based on the allegations of the complaint, the seller and your client were well aware of the possible claim, adverse claim of the condo association. I'm trying to see how, if that's the case, how this isn't another misrepresentation.
Well, if they were talking about the 4 corners of the document and the integration of the contract that puts the person on notice through paragraph 20, Your Honor, then that investigation would be there isn't a cause of action for misrepresentation with disclosure. All of the case law, I mean, we're in a Billington versus Smith problem again in the 5th that I know Judge Torpy sent up years ago, and it never went anywhere, unfortunately, with the Supreme Court. But we're dealing with actual concealment, actual misrepresentation without disclosure. And in the 4 corners of the document, when you attach the contract, which creates and gives the disclosure of the issue, now we're stuck with saying, okay, is there a cause of action that could be repled that brings the broker or the agent into play right out of the gate? And I don't believe so
Well, if
with what we have.
If the condo association had told your client, told the broker and the seller, that if you do this, we're going to sue, would paragraph 20 change the result of your representation that there's no anticipated litigation?
If they had said we're going to sue, yes, and in fact they said we're not going to take a position in it. We're just saying we don't believe you got that unit. And then it goes back to the condo. What did the condo association actually say? They didn't say you don't have the exclusive use. They said you don't own that unit to use at all from a title perspective.
Well, we don't know that from the complaint, do we? Doesn't the complaint allege something different?
Again, I agree, Your Honor. If we're now going to go where we need to, which is staying within the 4 corners of the document and then
Right,
taking the
so that-
attachment, paragraph 20, there's disclosure for the buyer now obligating themselves to going and finding out for sure what is or is not there.
Well, if we don't know what that estoppel letter says, then how could this complaint be dismissed with prejudice?
Because ultimately, Your Honor, we're going to get right back to the case law that stands for the proposition that you can't, if you can't plead properly to get around with prejudice, and there's no cause of action. I mean, first, there is no 475 claim in the complaint we're here before you on. And B, with disclosure, if paragraph 20, paragraph 14, and the rider all come into play, is there sufficient disclosure? Well, then 475 can't be pled around in the first place. Fraud still has to have the specific intent. The disclosure negates a fraud claim, which is Billington, and then you end up with an issue of, okay, was prejudice an abuse of discretion or not? And I don't believe so, because negligent misrepresentation would require our agent to have been the agent for the buyer, and then you would have had to have had a concealment, no disclosure. The court's going to have to wrestle with, is the disclosure in paragraph 20 sufficient or not in
What
order
is
to get...
paragraph, what does the words "cannot guarantee" mean?
Well, again, cannot guarantee the title, cannot guarantee that there's not going to be somebody that says, hey, I get to use that garage by property ownership, by somebody in the condo association saying, I actually own that garage. The condo association itself, Your Honor, has the obligation to uphold all limited common elements and fix them pursuant to somebody's title. And I apologize, I call her Miss D because the name is difficult. I don't mean offense by that. Miss D simply has to say, association, while I appreciate your position, you have to maintain the common element. That's what the declarations say. All you have to do is fix it. It doesn't matter who it's for. And if some person comes out and says to me, I own that garage, maybe my title somewhere that the title company gave me is an issue. But until then, the condo association doesn't get to make that determination. The developer may have, which is the whole reason we say the developer didn't give information that specifically outlines where that title is. You're allowed to review the entire record.
And that the words "cannot guarantee" remove any obligation on the part of the seller for anything?
I don't know that it removes obligation, Your Honor.
What if it
The issue of
said,
the
what if
ca-
it said "cannot guarantee" title to the unit?
Sure. The issue is
Does that
just...
mean that you know, if you took the however much money for the unit and then turned out you didn't own it in the first place, then you're off the hook?
The issue is disclosure, Your Honor. The issue of the four corners of the document and paragraph 20, and the issue before the court of a fraudulent or negligent misrepresentation
What are you
is
disclosing by the
disclosure.
words "cannot guarantee"? I mean, you went through just now a long statement of what "cannot guarantee" means. Well, why wasn't that in here? Instead of just the words "cannot guarantee," which can mean all sorts of things.
Well, I mean, again, I think if you get to the typewritten provision that's specifically laid out to do so, and a realtor putting together the contract, are we talking about a 20-page typewritten documentation, or are we talking about disclosure of the issue that is sufficient to put the buyer on notice for them to make their own further investigation? The appellant has stated very clearly that she asked at least three different times what the issues were. And she got the answer from the agent, she got the answer from the title company, and then at the closing, she gets it again when she says in her own declaration, I relied on the title company telling me I'm getting rights to all three garages. And that bundle of sticks we own exactly got transferred to them. So clearly the disclosure by the appellant's own admission was given, and any further investigation that should have been made could and should have been made by the buyer, Ms. D.
Isn't this more summary judgment discussion, though? I mean, at the end of the day, you know, following up with Judge Evanderson, but your client's aware that there's something being raised by the condo association vis-a-vis 1 versus 3 garage units. She could have simply put in the right, you know, in there saying, okay, there is some discussion that the condo association does not believe that you'll have the right to all 3 units, and we disagree with their assertion. There's been no judicial determination, but we're putting you, Ms. D, on notice of that. If you want to proceed, go forward. If not, your call. But your client has allegedly not done that, and the documents suggest that she hasn't done that. In the context of we're here on a motion, you know, dismissal of a case with prejudice on the first amended complaint, that there can be no causes of action possibly asserted based on those facts. And I'm just having a hard time,
Sure.
I think, as Judge Evander is, as to why that this is a case that perhaps you win at summary judgment. I don't know that, obviously.
Sure.
But at this point, why it's over.
Well, Judge Lambert, I mean, as the appellee, I don't get the luxury of would it have been better in summary judgment, or was our failure to
You
state a
thought it
cause
was,
of
'cause
action?
you filed one later.
We did file
Yeah,
one, and it didn't get heard, but we filed one because the determination of, okay, do they not state a cause of action because of the disclosure issue, and does the court deem the disclosure in paragraph 20 along with the riders sufficient to not state that cause of action? But I don't get the right to say which one of those motions would have been better heard by the court, unfortunately. I do believe, however, Your Honor, that the motion to dismiss was well pled and well founded on the fact of the disclosure that the four corners of the documents with the contract that is incorporated doesn't state a cause of action. I find it, quite frankly, more problematic, the with prejudice issue on a amended complaint, than I do with the finding of the court that there's simply no cause of action stated at the moment. Then you have to go to the secondary analysis, which we did for purposes of appeal. Could there now be a pleading that is put forth that brings 475 in? And I believe, Your Honor, if we look at the disclosure, if the court deems the disclosure adequate, then 475 won't apply, because 475 requires that specific intent issue, the fraud. It still requires the negligence elements of the duty. Those kinds of things are going to come into play. Now, I will say,
So if the disclosure is, if we think it's inadequate,
if the disclosure is inadequate, then I believe the with prejudice is certainly the best argument for the appellant, because it was only an amended
well,
pleading.
I mean, you didn't argue, unless I'm wrong, you're not saying that the allegations of the complaint in and of itself are not sufficient. You're saying that the attached exhibit negates that, therefore it's insufficiently pled because of that attachment. Is that right?
Yes, partially, with the additional argument, Your Honor, that if they're going to state, as they do in the amended complaint, that we did not transfer good marketable title and use to those units, the garages, that they also must attach the documents to the case, the deeds, to show. So we have a failure of stating a cause of action, one, because of the disclosure, and the secondary part is the documents that are attached don't paint the picture for any court, as far as we're concerned, to properly adjudicate the merits of the case. It's a far different cry to say, the title company, you got a warranty deed with title insurance to everything. And what does that mean when you are now going to say, I need you, condo association, to fix my garage because the door won't open correctly?
So what if she pled, you know, all right, I've closed, now I've tried to use these other two garage units, and I'm banned, I can't get in there. They've got armed guard there or something like that. They said you can't do it, and
But she says the exact opposite. The exact opposite.
she's pled that I have easy access and use to all of them.
In her declaration, she says, no one has actually tried to stop me at all from using the garages. I have the clickers, I have access, I have everything. One of the garage doors don't open correctly. I asked the association to fix it. They say they won't fix it. And there's the real rub. The association doesn't get to choose to fix a limited common element. All limited common elements must be fixed, must be able to be used, because that's the requirement of the association.
Mr. Wiedemann, I think you're taking the position now that the appellant is not or should not have gotten deeded access to the 3 garage spaces, correct? Based upon the documentation, would not have gotten deeded access to the 3 garage spaces, correct?
No, Your Honor. I'm sorry if I misstated something of that. I believe our bundle of sticks included the unit and 3 garages and was supposed to be deeded our bundle of sticks to Miss D.
So is that title to the parking spaces or just exclusive use?
It's both. The issue of use is not an issue for anyone other than Miss D to say she owns, until or unless a unit owner, not the association doesn't have limited common element use. It's an assigned use through the deeds to all unit owners. No unit owner has made a single claim. So the condo association, unfortunately, doesn't get that right to choose. If they had proper documentation going back to the developer, where assignments were followed, because if you also have read the deposition of Ms. D, I showed the other garages that are claimed, 19A and B, are actually deeded. Oh, and the association document says these garages are somewhere else. Well, the other units that they're claiming actually have a deed for their own separate garage. They don't even match up with any of the documentation for the association. So the
But you're saying the parking space can be subject to title?
parking space as far as title ownership of the limited common element owned by the association, title in its pure sense does not transfer, but that title gives that use.
Okay, so do you clarify that based upon, what I'm specifically looking at that I have a real problem with is this MLS listing that I believe your client was responsible for. Your client's name is at the bottom of this MLS listing, correct?
Yes, Your Honor.
Okay, and I find it rather extraordinary that in that MLS listing, your client specifically says not one or two, but 3 deeded garages come with this unit. So bring your beach toys and collectible cars.
Yes, Your Honor.
That's, I believe, very inconsistent with the way this case is played out and directly opposite or contrary to the estoppel letter. Would you agree?
No, Your Honor, because we deeded via warranty deed exactly that to Ms. D. And she agrees in her declaration that is exactly what she got via deed. We deeded through warranty deed and title insurance the Unit 301 and all 3 garages.
What if the deed is wrong? That your client only had 1 space they had title to, and yet they gave a deed for 3?
Then the title company, Your Honor, as far as what was transferred in those bundle of sticks would have to be negated in the pleadings by a unit owner claiming an interest in the property, not the condo association, and that's where the difference really relies. There isn't a pleading that they can make that shows a unit owner is making claim to what was delivered via deed to Ms. D.
What if the condo docs, which we don't know, what if they say that these 10 units belong to the condo, or these 10 parking spaces belong to the condo association, which would not be uncommon to be used by guests, et cetera, and everyone else gets 1, and there's 10 extra ones. Who owns the 10 extra ones in the condominiums that everyone has 1 space, and then there's 10 extra ones for guests? Who owns those?
If it's via the title documentation or by the developer, which is the document we don't have, then you gotta follow the title and the chain of title from the beginning of time to
Right, and the
that
title
unit owner.
the original title might give certain number of parking spaces to the condo association, right?
It might, it
We don't
doesn't.
know in this case.
Well, we actually do, but not for purposes of the 4 corners of what's pled, Your
Right.
Honor. But in her deposition, which is the record before you, we've cured that problem because we show the record title of what the condo association does say was given out as garages to being completely different. So we know Ms. D got the 3 garages.
All right,
Okay.
counsel, you've
I apologize,
exhausted your
Your
time. You want to wrap it up in the last 30 seconds?
Just one last thing, Your Honor. There was a question about, that you had asked, Judge.
Lambert.
The applicable statute was not in place at the time of this disclosure. The law change of did the judge have to make a determination for the court on the motion to dismiss, that was after the time of this hearing. So I just wanted to make sure I answered the question, Your Honor, that at the time, Judge Jacobus did not have to make a specific finding. Other than that, Your Honor, I believe based on what's pled, the dismissal should be upheld. Thank you, Your Honor.
Thank you, counsel. All right. Mr. Whitehead, you have 7 minutes, 6 seconds in rebuttal.
Yeah, just very, very briefly. The condo association, the condominium property is a unit owner purchases a unit. Then spaces that are pertinent to that unit, such as garages or assigned parking spaces, are limited common elements. Just like a common element, only it's limited. And those, as we all know, the common elements and limited common elements are owned and controlled by the association, or actually by all of the unit owners in the condominium. So if there are 32 condominiums, each unit owner has 1/32 ownership interest in common elements and limited common elements. Limited common elements are assigned so that you have the exclusive right to use that limited common element. Title is not the issue. You don't get title to a limited common element. You get the exclusive right to use it. And what was promised, Ms. Jigalewski, was exclusive right to use 3 garage spaces, as indicated in the MLS listing. An MLS listing that remained in place after, as we allege in the complaint, Ms. Scalero, who's not the owner, but was the realtor making the representations, or misrepresentations, she was expressly told that that MLS listing is misleading.
So in paragraph 20, when it says the seller can only guarantee title to 1 parking space, that's kind of meaningless because they didn't give title to that parking space anyway?
I don't know that it's meaningless. I think, people misconstrue that all the time
Is the title or is
innocently.
the proper term guarantee exclusive use?
It should be guaranteeing exclusive, if it said, we can only guarantee exclusive use of 1 of these parking spaces because the association is disputing our right to use all 3, or words to that effect, which they knew and had at least lost 1 sale because of this very issue. And, paragraph 20 is, in my humble opinion, misleading. It's
So if they had
part
said
of the
what you
fraud.
just said, then you'd have a hard time here.
We'd have a hard time. We would have said, wait a minute, we're not doing it.
Or if she went forward, you'd say.
She would've went
if
forward
she went
and-
forward and then she couldn't use the other 2, you'd say, well, ma'am, you understood that was the roll of the dice.
And bought the
Come up
problem.
snake eyes, or whatever's the bad one. The snake eyes the bad one?
Right, so the,
Does the estoppel letter create a sufficient cloud on the title with regard to the right to use the 3 garage spaces?
it's not a cloud on title, and
I understand the term as far as title, not as far as the use of the garage spaces, but I'm saying the right to use the garage spaces. Is the estoppel letter, for purposes of the title insurance, going to create any cloud or give any indication that that use would be in any way prohibited or frustrated?
an estoppel letter would have put Ms. Jigalewski on notice that there's a problem here, that, hey, the association who controls limited common elements, and an estoppel letter is from the association, and it's part of a closing, and when you have a condominium closing, it's part of what the title insurance agent obtains, provides, and of what Ms. Scalera, according to the allegations in the complaint, was well aware of. An estoppel letter tells you, hey, there are unpaid assessments, there's a special assessment, you are inheriting these problems. It also deals with garage spaces, and it disclosed this garage space issue. This is not a problem that's covered by title insurance, because title insurance excludes limited common elements, because it's not a title issue. It's an issue that has to do with exclusive right to use. So this is not a problem that's covered by title insurance. It's an express exclusion from a title insurance policy. So the fact that the realtor knew about this, was asked about it on numerous occasions, as alleged in the complaint, was told by the association your MLS listing is misleading, didn't do anything about it, continued to advertise it, and then puts a provision in paragraph 20 saying we can't guarantee title, which is really almost meaningless, because title's not the issue when it comes to exclusive right to use, and then includes an addendum that says you have the exclusive right to use these 3 units. It's fraud. Thank you. That's all I have, unless there are any other questions.
All right, thank you, counsel. All right, counsel, we'll take this under advisement. Well argued, interesting, over two parking spaces. All right. Thank you. Have a nice day. Have a good trip back.